y bienvenido a mi canal. Yo me llamo Sirey. Soy una abogada afro-latina licenciada practicando la ley criminal, pero como todos ustedes, a mí me fascina cuando estamos hablando de casos de crímenes reales. En este video vamos a continuar hablando de David. Si quieren más video en español, nada más dime allá abajo. Hi everyone and welcome back to my channel. My name is Desiree. I'm a licensed and practicing Afro-Latina criminal attorney who, much like the rest of you, has a severe fascination with true crime cases. Listen. You guys, normally I cut out the little edits and stuff of me being weird or whatever, but like I almost choked on my spit doing all that smiling and all that listening and all that stuff. So y'all just gonna see it. If I later decide to edit it out of the video, I guess you just won't see it, but good Lord. Listen. Okay, you guys. So I think we're going to talk about David today, but let me tell you what we're going to talk about, because it's come to my attention that David's preliminary hearing has been continued once more. So the date that we were previously talking about, some date later in May, is not going to happen. Now we're set at the end of June to listen to this preliminary hearing, okay? And before we get there, there are some things that I feel like were just loose ends that I want to tie up. So without any further ado, let's go ahead and get started in our continued coverage of David. Okay, you guys, so if you remember from my previous David videos, David was originally arraigned on this case on April 20th of 2026. Okay, keep that date in mind. That happened to be a Monday. Originally, so for the first preliminary hearing setting, he was set to be seen for his preliminary hearing before the court on Friday, May 1st of 2026. Okay, I'm going to keep going in the timeline and then I'll explain why I'm placing emphasis on these dates in just one moment. Okay, just bear with me. Then, after the preliminary hearing brief that we went over in one of my past videos about David, the preliminary hearing was continued from May 1st to May 26th of 2026. You following me? You following me? And now we're past May 26th as I'm recording this video. It's my understanding that the preliminary hearing has been rescheduled for June 29th of 2026. Okay, so as I'm recording this video right now, I'm not aware of any additional documents that we need to discuss. I'm also not aware of anything, any additional dates other than the prelim I just told you about that we need to address. But what I do want to make clear is some things that I don't think I addressed in my last videos. And because, I think you guys like listening to me talk about this case, I figured I'd just make a whole video to address it. Okay, you guys, so I know I've been very specific with you guys in explaining to you the purpose of a preliminary hearing and, why a defendant would request one when he's entitled to one and the like, right? So let me just repeat it for any of you who are just finding me on this video, just in case you've never heard me say it before, because again, I will be the broken record that everyone needs me to be. A preliminary hearing is merely a hearing by which the court determines whether or not there's probable cause to proceed as to the specific charges filed against the specific defendant. Do you want me to say it again? Don't worry, I got you. A preliminary hearing is merely a hearing by which the court determines if there's enough probable cause to proceed as to the charges filed against the specific defendant. There are a few things I realized I didn't mention to you guys with regard to preliminary hearings. And we're getting into the weeds just a little bit, but I just want you guys to understand it just a little bit further, okay? And you guys can tell me down below, Desiree, this video wasn't even necessary. I don't need you to explain this to me. I just want to know the basics. I want a rudimentary understanding. And I may listen to you because sometimes I just want to explain it to make sure we're all on the same page. But anyways, let's go ahead and carry on. So you guys, first and foremost, preliminary hearings are only held when a defendant is facing felony charges. Got it? Got it? I'll say it again. A preliminary hearing is only held when a defendant is facing felony charges. So what I'm saying is, if there is a defendant who only has misdemeanor charges pending, they are not entitled to a preliminary hearing. That is important. We know that David's facing 3 separate felonies as it relates to his alleged criminal conduct with Celeste. But let's just be clear here. Should, for whatever reason, all of these be downfiled to misdemeanor charges, which is not going to happen. But should that happen, for the purposes of this hypothetical, he would no longer be preliminary hearing eligible. Does that make sense? Okay. Now, also, preliminary hearings are only for specific felonies. I know I'm going so into the weeds with this, okay? Now, let's say it like this. typically, and I know there's different classifications based on different states, but typically there's 6 separate classifications of felony. Okay. Typically there's 6. And again, I'm not licensed in California, but I'm just telling you, just basically, let's say there's 6. Okay. And there's 6 where I'm licensed. So let's just use my states, for example. Okay, cool. Felony class 1, 2, 3, 4, 5, and 6. Typically, a defendant is not eligible for a preliminary hearing when the class felony is lower than a 3. Does that make sense? So F1, anyone who has been arrested and charged with a murder is entitled to a preliminary hearing. Let's just keep it there. F2, assault with a deadly weapon causing serious bodily injury. They're entitled to a preliminary hearing. F3, a robbery or a first degree assault that doesn't involve serious bodily injury and doesn't involve a weapon. Still eligible for preliminary hearing. You got this? But when we're dealing with F4s, F5s, and F6, you're not necessarily preliminary hearing eligible. And listen to the word I said, necessarily. And that is because the penalties on those are so low that it's not really of consequence. And I don't want to say that, a felony class 5, 6, and 4 or whatever is not a big deal. They're huge deals. But if we're dealing with an F6 motor vehicle theft, it's not as severe as an F1 murder. Do you feel me? You follow me? You follow me? You follow me? You follow me? Now, let's go back to the word that I said, necessarily. When does someone charged with an F4, F5, or F6 become preliminary hearing eligible when they would otherwise not be? When they're in custody. Okay? Okay? You follow me? You follow me? You follow me? So if there is a defendant who is facing an F4, an F5, or an F6, and they are not in custody, there is no entitlement to a preliminary hearing. However, should the defendant be in custody and now they have an F4, F5, or F6, they are entitled to a prelim. Got it? Got it. Now, let's go back. Let's talk about the dates and the timelines that I mentioned to you, right? So David was arraigned on April 20th of 2026. What do we know about his arraignment? Arraignment is just a hearing by which the court advises the defendant of all the charges pending against the defendant. In a lot of circumstances, the court won't directly advise the defendant, meaning the court will say to counsel, in this case, Ms. Burke, did you advise your client of the charges? Do you waive reading and advisement? Basically, right? But it's just a hearing by which the defendant by some mechanism is advised, or the court records the fact that the defendant's attorney has advised him or her about the charges pending against him or her. Does that make sense? Now, that happened on April 20th. What else do we know about the preliminary hearing? What else do we know about the arraignment? We know that this arraignment occurred while David was in custody. Now, here's another special rule that I'm about to share with you guys about preliminary hearings, because I'm just getting super, super, super nuanced because you guys are brilliant. I see it in every single question you ask me. I see it in all your comments down below, and I just love talking to you guys, okay? A defendant who is in custody is entitled to a preliminary hearing within 10 days. You want me to say it again? A defendant who is in custody is entitled to a preliminary hearing within 10 days. Are there exceptions to the rule? Of course. The law has numerous exceptions to absolutely everything you can possibly think of, right? The first and the most common example that I can think of is that the defendant waives his right to have a preliminary hearing within the 10 days. Second, and less common, but also common, but like less common, the prosecution establishes good cause for the preliminary hearing to be set outside of the 10 days. Okay, does that make sense? Before I give you guys a further explanation of each of these, let's go ahead and insert the clip from the arraignment where Blair Burke asked the court to set the preliminary hearing as soon as practicable, but not outside of the 10 days.
Calling People versus David Anthony Burke. That's case number 26 CJC F02399.
Good morning or good afternoon, Your Honor. Blair Burke, Marilyn Bednowski, and Regina Peter, on behalf of our client, David Burke, who's in custody.
Thank you. And good afternoon, Mr. Burke.
Deputy District Attorney Beth Silverman to the people, Your Honor.
Thank you. And counsel, on behalf of your client, do you waive formal reading of the complaint, advisement of rights, including armed forces and veterans' rights, enter a plea of not guilty, denying any and all special allegations, enhancements, and priors,
Yes, Your Honor.
and you're requesting a preliminary hearing within the period.
Yes, Your Honor. From the media reports, apparently there have been 4 months of secret grand jury proceedings. We believe that Mr. Burke is entitled at the earliest opportunity to an open preliminary hearing and the proceedings not be done in secret. So we are asking for a preliminary hearing to be set at the earliest possible date on the 10th day. Your Honor, we believe the actual evidence will show David Burke did not murder Celeste Rivas Hernandez, nor was he the cause of her death. And we would like to be able to have the evidence come into the light of day at the earliest opportunity in order to establish that. We're asking for April 23rd as a 3 of 10, Your Honor.
Okay, you guys see the reference? You see what I was talking about? Now, let's continue. So, what happens if the prosecution or the court or whoever happened to set the preliminary hearing outside of the 10 days, the complaint or the charging document, indictment, whatever it is, but in this case, it's a complaint, gets dismissed against the defendant? You don't believe me? Why would I lie to you? For further verification, let's go ahead and read the California statutes that say what exactly I am saying to you. California Penal Code Section 859B reads, whenever the defendant is in custody, the magistrate shall dismiss the complaint if the preliminary examination is set or continued beyond 10 court days from the time of the arraignment, plea, or reinstatement of criminal proceedings pursuant to Chapter 6. And the defendant has remained in custody for 10 or more court days solely on that complaint, unless either of the following occur. A, the defendant personally waives his or her right to preliminary examination within the 10 days. Or B, the prosecution establishes good cause for a continuance beyond the 10 court day period. Now, let's talk about the first exception. I think it's pretty self-explanatory, but I'm going to try my best to find a way to explain it to you anyway. The defendant waives his right to have the preliminary hearing within 10 days. Basically, Blair Burke or the other attorney that's defending David in this case would go up before the court and say, Your Honor, our client waives his right to have the preliminary hearing within 10 days. Really, that's it. The court might have a short colloquy with David, asking him if that's the case. Like, do you understand you have a right to have a preliminary hearing within 10 days? Yes. Do you waive that right? Yes. And then they set it outside the 10 days, right? Or the second exception is that the court finds that the prosecution has established that there is good cause to set outside the 10 days, and there's still no waiver from the defendant. Some examples I can think of this is like this. Okay, so I've told you guys before, I've done preliminary hearings before. It is very uncommon for a preliminary hearing to have multiple witnesses. It's just not really common. I say that fully understanding that the prosecutor here is probably going to have a million witnesses just because that's her prosecution style. I'm just saying, I don't think it's really common to have multiple witnesses. I think in my experience, 1 or 2 witnesses tops. Okay. That's the prelim, 1 or 2 witnesses tops. And why is that? Because I told you guys before, the bar for a preliminary hearing is really, really low. The court has to give the prosecution every benefit of any reasonable doubt. And, you know, there's what it is. Okay, so one specific example that I can think of right now of the prosecution being able to establish to the court that they need to set the preliminary hearing outside the 10 days and good cause has been established to do so is, let's say the prosecution is only calling 1 witness in this case for the prelim. And again, I don't think that's going to happen, but let's say there was only 1 witness and that witness has emergency medical leave or something, is gone, you know, something like that. And they can't come and testify on that 10th day, and that is the only witness that the prosecution is calling, I think that the court might find good cause for that, even absent the defendant's waiver of the 10 days. Does that make sense? 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 Anyways, let me stop. Let's carry on. Okay, you guys, another thing that I want to talk to you guys about specifically is the grand jury investigation or investigations that were done in this case, okay? I remember telling you guys that here are my 2 educated guesses as to why the grand jury didn't find probable cause, blah, 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 blah. right? Okay, cool. Since then, and I also told you guys that if I found more information, I would let you guys know what I find, okay? Now, I'm still guessing because none of this has been confirmed by the LA County District Attorney's Office. So I'm still guessing. I am still guessing. But I saw a few reports, I think one or two, that mentioned that the grand jury wasn't a regular grand jury, but instead it was a special grand jury. Man, and that changes the game.
It's being reported now that the investigation into the death of 14-year-old Celeste Rivas Hernandez has taken a major step. Allegedly, a grand jury has been impaneled in this case, but not any grand jury, a special one. We're going to dig into whether or not this is possible, what it could mean for potential charges, suspects, and how this is all centered right now on Singer David. Welcome to Sidebar, presented by Law and Crime. I'm Jesse Weber. Well, it seems the twists and maybe confusing turns in the Celeste Rivas Hernandez death investigation are continuing because this time, after TMZ reported that LAPD told them that there were no arrests that are imminent in connection with the 14-year-old's death and disposal of her body. Remember, her corpse was found back on September 8th in a Tesla reportedly registered to Singer David out in LA. Now it's being reported that according to the LA Times, law enforcement sources say evidence has been presented to a grand jury already. Now, it's an investigative grand jury to be more precise. We're going to talk about what that is because it's our understanding they can't return an indictment, right? So we're not talking about formal charges just yet, but an investigative grand jury certainly plays a key role in certain criminal cases.
I did promise you a true crime program tonight. That's true crime on the politics side. Here's the rest. And this might be the biggest development in the David and Celeste investigation. Of course, since the police, spent hours raiding that singer's former Hollywood mansion back in September. The Los Angeles Times just broke the news that an LA County grand jury is now hearing evidence submitted by prosecutors related to that runaway Celeste's death, or what police are now actually calling a murder. The Times calls this an investigative grand jury, something that's used to subpoena witnesses and other evidence. While this kind of grand jury can recommend charges, it can't do the actual indicting. But true to form, the LA District Attorney isn't commenting. We did get this statement, non-statement, whatever you want to call it. It says, in accordance with longstanding office policy and California law, we are not at liberty to discuss or disclose any information about grand jury proceedings. There you go, end quote. So that didn't get us anywhere. But now it's official. The investigation into the death of Celeste Rivas Hernandez is in fact a murder investigation.
Okay, now that you guys got time to see the clips that I was referencing, or at least one of the clips that I was referencing, let me go ahead and explain to you the difference between a grand jury and a special grand jury. Because again, this changes the game. If it's true, I'm still just guessing because we haven't received confirmation from the district attorneys, but here's what it is. So the entire purpose of a regular grand jury is to determine whether or not there's probable cause as to the charges against a specific defendant. So they're a probable cause finding grand jury. Does that make sense? A special grand jury is different because their whole purpose is like an investigative grand jury. Now, why is that different? Their purpose is not to determine whether or not there's probable cause. Not at all. Not in the slightest. Instead, they listen to all the evidence that's placed before it, determine whether they think that evidence is strong or whatever, and make determinations or make decisions or, I guess, suggestions as to how the evidence might be a little bit stronger. So if this were true, this makes sense to me because it's my understanding that there's multiple grand juries that occurred here, right? And so it would make sense to me that they were investigative grand juries to determine whether or not there's enough evidence against David before formally charging him. Does that make sense? Does that make sense? Okay, great. Now, because that's so important, let me just tell you guys my opinions about this case really quickly, and then let's just go ahead and wrap up this video because I just wanted to give you a cute little David update, and it's not cute. Nothing about this case is cute, but you know what I'm saying. I just wanted to make a video with you guys or talking to you guys just about some of my thoughts about this case before we head into the preliminary hearing, should it even occur. I know you guys aren't going to like the fact that I'm going to say this, but I'm going to say it anyways because I try my hardest to be as honest as possible with you guys, even if we might not agree on everything. In my opinion, and I might have said this in a previous video, the evidence against David pertaining to the first-degree murder charge as it relates to Celeste wasn't the strongest initially. Don't write me off just yet. If the special grand jury did convene on different occasions to determine the strength of the evidence here, that would lead me to believe that the prosecution kind of agreed with me initially. So before charging David initially, they wanted to make sure to have all their ducks in a row. They wanted to make sure their evidence was a little stronger. And they reworked their case, found more evidence, grabbed the strength, and then charged him. Does that make sense? Okay. Okay. Does that make sense? Now, as far as the preliminary hearing is concerned, despite the fact that the prelim has been continued twice now, it wouldn't surprise me if David and his attorneys reviewed the evidence that they have available to them right now and determined that they no longer want to proceed with a prelim, because it happens all the time. It just does, right? So if the case happens to go to the preliminary hearing, and if we're able to see that preliminary hearing, I will share my thoughts and opinions on it with you. Okay? Okay? Okay. There's another caveat that I'm not sure if I mentioned in a past video. Let's actually say I don't think I mentioned it, because I don't think I did. Because this is a case against a minor, and the charges relate to alleged sexual assault against a minor. And I'm assuming some of the evidence will relate to the alleged sexual assault of a minor. It might not surprise me, or I don't want you guys to be surprised, if they don't air the hearing in its entirety. They might not air it at all. Or if they air it, they might choose to air it in limited fashion, you know? So I just don't want you guys to be surprised if you don't see that it's completely aired, okay? But regardless, we'll talk about it if it happens, and I'll give you my opinions on it, okay? That is it for this video. But like I told y'all last time, I'm going to keep saying this in every video. I love, and I hit myself on the microphone, talking to you guys. I absolutely love it. I love it. It's honestly probably one of the best parts of my day. It's fun. It's educational. I enjoy sharing my opinions on these cases with you guys. I enjoy the cases that we're reviewing, and not in a weird way, just in a astonishment way, right? I share the astonishment with you guys, and I really love when you tell me how much you enjoy these videos. If you like them, can you please tell me you like them? Tell me what you like about them. Tell me what you feel about them. Tell me if you have any questions about this video. Comment, like it, subscribe to my channel, please. I beg of you. I'm not begging y'all. No, I don't beg of you. I ask of you, okay? As always, thank you guys so much for watching. Please be sure to like, comment, share, and subscribe. Until next time, y'all take care.